Dictation will start in 5 seconds. Start. The normal rule of human conduct is that if a person wants to confess to the crime committed by him, he will do so before the person in whom he has implicit faith. It is not the case of the prosecution that the appellant had a close acquaintance with PW1 for a certain length of time before the incident. Moreover, the version of the witness in examination in chief and cross examination is entirely different. Therefore, the testimony of PW1 is not reliable. Hence, the case of extrajudicial confession cannot be accepted. Between the house of the deceased and the pond, there is a road and ridge of the pond. This means the appellant must have dragged the deceased for a considerable distance. The incident happened in the evening before 7 p.m. There must be many people around the place of the incident. None of them has been examined as a witness. An adverse inference must be drawn against the prosecution for not examining material witnesses. Moreover, in the absence of injuries on the body of the deceased, it is very difficult to accept the testimony of PW5 that by holding the hair of his mother, the appellant dragged her to the pond. Therefore, evidence of PW5 of last seen together is not worthy of acceptance. Guilt of appellant not proved beyond a reasonable doubt. Appellant is acquitted. Cross examination of the witness by the public prosecutor shows that the witness was not confronted by showing the relevant part of her statement recorded under section 161 of CRPC. The witness ought to have been confronted with her prior statement in accordance with section 145 of Evidence Act. Normal rule of human conduct is that if a person wants to confess a crime, he will do so before the person in whom he has implicit faith. The Sessions Court convicted the appellant accused for the offence punishable under section 302 of the Indian Penal Code, for short IPC, for committing the murder of Srimati Hemvati Bai, who was his stepmother. Appellant was sentenced to undergo life imprisonment. By the impugned judgment, the High Court has dismissed the appeal preferred by the appellant. The case of the prosecution, in brief, is that the appellant had a land dispute with the deceased. The allegation against the appellant is that on 2nd March 2013, he assaulted the deceased. After that, he caught hold of the deceased by her hair and dragged her up to the village pond. The appellant put her head inside the pond water. The deceased was suffocated to death. The first informant, Darsu PW4, informed the police that Hemvati Bai died due to drowning. Accordingly, a first information report, for short FIR, was registered. After the completion of the investigation, a charge sheet was filed against the appellant. The prosecution examined 10 witnesses. There is no direct evidence. The prosecution relied upon evidence of PW1 Sukhmani Bai, the village officer. The prosecution case is that the appellant made an extrajudicial confession before the witness. The prosecution relied upon the evidence of PW5 Chaprasi, the deceased's brother. According to PW5, he saw the appellant holding the hair of the deceased and was taking her towards the pond. Though PW1 was declared hostile, the trial court and High Court relied upon a part of her testimony. The courts also believed the testimony of PW5. Sri Sridhar Y. Chitale, learned counsel appearing for the appellant as amicus curiae, has taken us through the postmortem report and testimony of relevant prosecution witnesses. Based on the evidence of PW9, Dr. Pankaj Kishore, his submission is that the death was due to drowning and the prosecution has not discharged the burden on it to prove that it was a homicidal death. He submitted that evidence of PW1, who was declared as hostile, cannot be believed as in the examination in chief the witness did not depose that the appellant made a confession of killing the deceased. However, in the cross examination made by the public prosecutor, the witness purportedly stated that the appellant confessed before her about killing the deceased. He submitted that evidence of PW1 cannot be believed. As regards the evidence of PW5, he stated that though the witness deposed that he saw the appellant dragging the deceased towards the pond, PW2 Bishoa, who was allegedly present at that time, did not support the prosecution. Moreover, another witness, Lakhan, was allegedly present there and was not examined by the prosecution. He pointed out that the incident happened in the evening and PW10 investigating officer admitted that there is a temple near the house of the deceased and other people lived nearby. He would therefore submit that the prosecution has failed to prove the appellant's guilt beyond a reasonable doubt. Stop.